Another myth that I want to talk about is the idea that there should be some kind of a cooling off period, that taking a break from the non-favored parent is a good idea.
Well, Kelly, couldn't giving the child a break from the parent they're angry at calm things down?
The research doesn't support that. And it actually can do the opposite, can have the opposite effect. For one thing, it sends the message to the child that the other parent might be too dangerous to be left alone with the child, and that the child will be harmed unless the target parent is limited in their parent time, unless they're supervised in some way. Court-ordered parent time should be enforced, and supervision or a cooling off period will more likely embolden the alienated child and the favored parent to continue pounding the drum of how horrible the non-favored parent is. And this will show the child that for them, they're in charge now. All they have to do is dig their heels in, throw a fit, and emphasize the negatives about the non-favored parent or demonstrate other negative behaviors, and they get their way. Well, we don't do that with 2-year-olds. We don't do that with 6-year-olds by caving to their throwing fits in order for them to get their way. Why would we do that with teenagers or children in this situation? And the research just doesn't support the idea that these cooling off periods work. More often than not, they have the opposite effect, particularly where the research says, look, you have to nip alienation and gatekeeping in the bud early. Tracy, another myth that often guardian ad litems, therapists, especially attorneys and alienating parents make is that, hey, if you force the child to be with the target parent, that is going to traumatize the child somehow.
How often are these claims made, Kelly?
In almost every case that I've seen, the word trauma is thrown around when the idea is proposed of forcing the parent time to happen. But the research also demonstrates that this is not true. The word trauma or traumatized are bandied about in the courtroom, but there's no peer-reviewed study or research that documents trauma actually happening. Trauma is a very specific psychological term. Any therapist who claims that the child will be traumatized should be challenged to support that assertion with valid psychological research. They won't be able to do it. But Tracy, every once in a while, I'll see also a claim that the idea of parental alienation is junk science, that it's not in the DSM, that it's been debunked, and therefore the court shouldn't pay attention to it. And it is in the DSM-5. In fact, the creators of the DSM-5 specifically talked about parental alienation and said that it could be categorized under 3 different categories. The DSM is the Diagnostic and Statistical Manual of Mental Disorders. This is like the Bible for therapists and psychologists, and it tells us when somebody has a mental disorder and what its symptoms are and things like that. And there are 3 different places in the DSM where parental alienation is categorizable under. Those being B6-129, a child affected by parental relationship distress, B6-120, a parent-child relational problem, and 995.51, child psychological abuse. Tracy, one particularly pervasive myth that judges and guardian ad litems and therapists sometimes believe is that the alienated child's preference, especially a teenager, should really govern because there's not much you can do about it.
Well, Kelly, doesn't there come a time, though, when, especially a teenager's opinion or input should kind of determine how things go?
The answer to that is twofold. One, in Utah, there is an age where the child's preference should be considered more heavily when determining custody. The statute in Utah is that at age 14, the court should consider a child's preference when determining whether the custody should be with mom or dad, but not parent time. There's nothing in the statute that says that the child's preference governs whether or not parent time should happen, and that's for good reason. reason is that a child does not have a fundamental or constitutional right to reject a parent. And the child's wishes are not controlling until they become adults. When can a child decide not to have a relationship with a parent? When they turn 18 and they're no longer a child. The other thing is this: when a child has been alienated, their capacity, their preference, their opinions have been diminished, they've been compromised. And so the court really shouldn't take into account the preference of a compromised, a coached, alienated child. That preference should be presumed to be contrary to the child's best interests. The final myth or misconception that I want to talk to you about, Tracy, is that courts can't really enforce parent time against the rejecting child's wishes, especially if they're teenagers and especially if they are large.
That's a really good point, Kelly. I mean, if a 15 or 16 or 17-year-old kid is really digging in their heels, there's not a whole lot you can do often. I mean, if you can't hogtie them and throw them in the back of the truck, what else is there at that point?
The research shows that children's protests against an alienated parent tend to evaporate when they're reunited for a lengthy enough period of time, and the alienating parent's influence is gone. And so one way that can be accomplished is courts can change custody, the courts can enforce supervision. There are other remedies that we're going to be talking about in the next segment. But let me ask you this, Tracy. If your child decided, hey, I'm not going to go to school today. In fact, I'm going to not go to school again ever. And by the way, Mom, I'm going to start using marijuana on a regular basis for recreational purposes. What would you as a parent do? What would you say? Would you just say, well, I encourage you not to do that, son, but I can't hogtie you, so there's not really much I can do about that? Or would you have more authority as a parent than that?
Oh, okay. Well, considering my children now are 5 and 8, they give me a hard enough time. I mean, there's things as a parent you just will have to do to enforce the proper, rearing and guidance for your child. And if that means taking it into court matters, I guess that's what I would have to do.
And with a teenager, you can take away driver's license, take away cell phone. You can also provide positive incentives. Hey, if you toe the line, you're going to get this reward. And that's a great way to do it. You can say, you wanted to go out for football this year or gymnastics. Do you think that's going to happen if you're not towing the line and going to school? Or all kinds of things that you can do as a parent to enforce the rules. Why would enforcing parent time with the other parent be any different? So those things can be done and should be done. If courts think, well, they're a teenager, what do you do? Sometimes there's this belief that parent time with the target parent, with the non-favored parent, is somehow different than all the other things that parents can make a teenager do. Hey, kiddo, get your rear end out there and mow the lawn, and if you don't, here's what the consequences are going to be. Consequences teach, but the lack of consequences also teach. If a court or a parent fails to enforce parent time, what are they teaching that kid? They're teaching that kid, hey, all I have to do is throw a fit and dig my heels in, and I get my way. That doesn't prepare them for life. That doesn't prepare them for the real world. It doesn't, and it has a whole host of other negative consequences. So to say that just because they're a teenager or that they're bigger than me, in every parental alienation case I have ever been involved with, the alienating parent says exactly what you said. What do you want me to do? Duct tape them and throw them in the trunk? They're bigger than me. I can't do that. But that kind of a response is ignoring all of the other parental authority that they have to enforce the rules in their own home.
Kelly, I've heard of alienation happening even if the target parent is represented by a family law attorney. Can't the attorney do anything to help or stop this? How is it that even experienced family law attorneys can fail to adequately